Hi, I'm Dr. J. Franklin Schultz, here to talk to you about report writing and domestic violence. First, let me remind you that your report is the single most important piece of evidence that will help the victim and the suspect get the most out of the justice system and the social services system. Your report will be seen by the victim, the offender, the victim advocate, the judge, the prosecutor, the defense attorney, the treatment providers for both the victim and the perpetrator, as well as those who provide services for any children involved, including custody hearings. Also the media, probation and parole agencies. Important research on domestic violence uses police reports to determine the causes and response to domestic violence. So even when the report is out of your sight, dozens of other eyes are on it, and it's going to be read for years to come. Because of the seriousness of domestic violence and the scrutiny that law enforcement is under from advocates and activists, one of the purposes of your report is to show that you followed all the best practices in your response to an investigation of an alleged act of domestic violence, also referred to as intimate partner violence, spouse abuse, and family violence. Having a DV report checklist is very helpful in these cases. We'll talk about evidence gathering and interviewing in a moment, but first let's talk about what our victim advocates want to see from law enforcement reports. Make sure that you document the following officer behaviors in the report. How you showed concern for the victim's safety, that you ask about the history of abuse in the relationship, that you ask about the treatment of children in the home by the suspect, and that you ask about treatment of pets or property in the home. Remember to ask about the use and presence of weapons and the suspect's access to weapons, and document that you made those inquiries in your report. Document that you ask about victim and suspect injuries, that you ask for statements from everyone, including children who were present. Ask if anyone else had any information that would be helpful. Document that you ask if there was a restraining order in effect at the time of the violation. That you ask if the victim had any questions about the process and what was going to happen. And that you provided victim assistance information. Remember that the law in Colorado puts the burden of victim services information on you as the police officer. Many times we let the victim advocates respond and provide that information, but if the victim declines a VA, it is still your responsibility to get that information into the victim's hands. There are several unique characteristics about domestic violence cases in Colorado. While other states include all family members as potential victims, Colorado's law requires an intimate relationship. And that does not include relatives other than spouses under that definition. By the way, notice that the intimate relationship requirement does not necessarily mean or require that the relationship is sexual. Officers sometimes ask the victim if they've had sex with the suspect, and the question may be intrusive and seem inappropriate to a victim. Asking what the nature of the relationship is usually answers that question. The victim may consider that there is no relationship, but if the perpetrator thinks there is, then the legal element may be met. According to Colorado courts, quote, a sexual relationship may be an indicator, but never a necessary condition, of an intimate relationship for purposes of the Colorado domestic violence statute. The relationship must be more than that of a roommate, friend, or acquaintance, and there must be a romantic attachment or shared parental status between the parties, end quote. This might be tricky where there is consensual sex between friends or roommates with no romantic attachment. Make sure you indicate in your report what the perceptions of the relationship are by the suspect and the victim. The other uniqueness of Colorado's DV law is that while most states make DV a separately defined offense, Colorado makes any crime a domestic violence crime if, quote, used as a method of coercion, control, punishment, intimidation, or revenge, end quote. And this includes the mere threat to commit that crime. Therefore, in addition to proving the elements of the underlying crime, the investigating officer has to prove the nature of the relationship and the intent of the perpetrator. Let me make a quick statement here about sexual assaults that fit the definition of domestic assault. Here the officer faces conflicting advice. Sexual assault victim advocates emphasize that victims should choose whether they want police involvement or not, but since domestic violence is a mandatory arrest, the domestic violence statute supersedes the options normally afforded victims of sexual assault by law enforcement. And we know that legally domestic violence under Colorado law is not a separate offense and is merely a sentence enhancer. The reality for the police is that DV has all of the characteristics of a crime for us because we have to investigate it, and in a unique way. Another unique characteristic of domestic violence is that it is a crime where the course of conduct is given great weight. Contrast this with, for example, bank robbery. If a bank robber has been convicted of bank robbery in the past and is currently on trial for a separate bank robbery, evidence of the first is probably not allowable in the trial to help prove this particular robbery. Where evidence of prior bad conduct might be ruled inadmissible in other criminal trials as being prejudicial to the case at hand, Colorado statute specifically allows the court to consider admitting that type of evidence in domestic violence cases if, quote, the evidence is offered to show a common plan, scheme, design, identity, modus operandi, motive, or guilty knowledge, or for some other purpose. That's why we ask about the history in the relationship, whether there has been prior intimidation or prior violence. However, a mere allegation of previous violent behavior may not be sufficient, so whatever evidence of proof of that prior history is available, you should include that in your report. Your report then must include any history or absence of it of abuse, including verbal abuse, economic control, isolation, or any of the characteristics we know about abusive and controlling relationships. This history can be important to show the intent of the perpetrator's behavior to be that of coercion, intimidation, control, punishment, or revenge. Of course, you must report your findings of any exculpatory evidence that the suspect had an alibi, a claim of self-defense or accident, or claim that the victim's injuries were self-inflicted or fabricated. As with any interview, watch the victim's physical movements as he or she describes how the perpetrator attacked, as they are describing an assault. People will often naturally mimic the physical actions that they are describing as they remember them, and finding congruence between what they are doing and what they are describing is an indicator of truthfulness. Recent research has shown that strangulation is a frequent component of partner violence, so you should ask the victim about that. This is commonly described as choking, but you should use the word strangle when describing the action of the perpetrator. Choking is when a person has difficulty breathing from a constricted airway. Squeezing or constricting the neck of someone else to cause death is strangling or attempted strangulation. So your victim may have choked from the neck compression, but they weren't technically choked by the perpetrator. Be sure to be as accurate and thorough as you can in describing the emotional condition of the victim and any children or witnesses. Remember that a charge of child endangerment or abuse is a likely concurring offense when a child witnesses domestic violence. Asking, are you afraid, and are your children safe, and how did you feel before the police showed up, can give some indication of the level of coercion, intimidation, or control felt by the victim. Listen to the dispatch recording and include a description of the call in your report, as well as a copy of the dispatch tape and transcript. Describe the characteristics of the behavior of the victim that reflect his or her distress from the event, if evident. These may be statements, but they also may be tears, trembling, excessive smoking, inability to think and speak clearly, etc. Avoid labeling such as afraid, visibly upset. Those kinds of things are subjective. Note if the victim has a physical, mental, or developmental disability as well, as this will be very relevant to the investigation. If the suspect is present, you should also observe and document his or her emotional state and statements. Claims of self-defense are common, and determining who the primary aggressor is can be difficult. The first harsh words or who started it don't necessarily tell you who the perpetrator is. When the arrest of both persons seems imminent, make quick review of all statements and evidence to see if you can determine the primary aggressor. That's the person who is exerting the dominant power and control in the situation, and you may be able to avoid a dual arrest. If the suspect is not present, be sure to document that you made a good faith effort to locate the suspect and get information at the scene as to his or her probable whereabouts. You should also make sure the victim knows that the suspect may be picked up and questioned later. If the victim changes his or her mind or is caught off guard by a perpetrator angry because of a delayed police contact, there's a danger of retaliation for which a victim may be unprepared. It is important that a victim know how to obtain a protection order if the suspect remains at large. As you know, a frequent problem with domestic violence is the absence of the victim at the time of trial or hearing. Since the Constitution allows defendants the right to confront their accusers, which amounts to being able to cross-examine them at trial, cases may be lost, even if there are compelling victim statements in the case file. The courts can see a difference between formal statements that result from your investigation and those statements made by persons during an ongoing emergency or your first arrival when you're just trying to figure out what's going on. Statements made during this part of the event may be regarded as non-testimonial and therefore be admissible even if the person who made the statement isn't available for cross-examination. If a witness doesn't show up because they've been intimidated or threatened by the defendant may have forfeited their right to object to statements being admitted without the witness present for cross-examination. Therefore, your accurate reporting of statements made during the ongoing emergency phase of your response and your documentation of the perpetrator's pattern of threats and intimidation can be used by the prosecutor to get statements admitted even if the victim fails to appear to testify. Be sure to ask about threats and gather evidence of notes, emails, and texts that indicate threatening behavior. And finally, the other unique aspect of domestic violence is the mandatory arrest requirement in Colorado. There is no other crime, not murder, not bank robbery, that mandates that an officer make an arrest on site. Remember that the mandatory arrest is only if you have probable cause. Probable cause is a set of facts and circumstances that would lead a reasonable officer to believe that a crime has been committed and that a particular person committed it. If you do not have probable cause, then an arrest is not required by the law. If there are leads to be followed, then continue the investigation and be sure to offer services to the parties involved. If you do not believe that sufficient probable cause exists, be sure to document in dispatch notes or a brief report so that no one thinks you just blew the case off. Society still struggles with what the best response to domestic violence is. Intimate partner violence is not just a crime, it sets the stage for future crime. It is also a political issue, a gender equality issue, and a social justice issue. Because of the high stakes in dealing with domestic violence, there are advocacy groups on all sides of the issue. So remember that you just have one job to do, to investigate a reported crime and determine if probable cause exists for an arrest. Being diligent and compassionate when investigating a DV can help move society toward a less violent one. Don't forget how important your work is in making our families and communities safer. Thanks for watching. Contact me if you have any questions or suggestions about this or any other presentation. Until next time, stay safe and stay smart.